So it is my pleasure to start this last session of the second day of our international workshop. And we are now going to deal with a topic which has been referred to a number of times yesterday and today, which means international courts, but as you see, reference will be made also to the Court of Justice of the European Union. And I think it's extremely interesting because judicial diversity is now related to neutrality. And of course, we are talking of international and supranational courts. So the issue of neutrality appears to be extremely relevant. Aida Torres is a professor from the university, from the Pompeu Fabra University in Catalonia. Her PhD was at Yale. Her textbook, her monograph is a textbook of my course on protection of fundamental rights in Europe. So as a matter of fact, a reference to what Torres says is quite frequent. And next week, as it is the end of the course, I'm going to have students make a presentation of 4 chapters of her book. So I suppose that what Professor Torres says will be explored in depth, and I hope faithfully, not only by the students, but faithfully by myself as well, of course. So it is really, and of course she's a very dear friend, and she has been a visiting scholar here at the law school in Trento. So and further, she organized a conference on the same topic last November, and I participated to it, and I say this because this indicates how much she knows about it, and so it will be a very interesting presentation. So, Aida, you have your 25 minutes.
Thank you so much. Actually, it's a great pleasure to be back to Trento and have the opportunity to meet all the friends here. So I thank Jens and Roberto for the invitation to such a unique, actually, workshop, because I've been listening to presentations about topics completely new for me, actually, and that has been really illuminating, actually, and I really enjoyed it. So I know I'm the only obstacle between you and the weekend. So
my conclusions.
Oh yeah, that's
it. Feel relaxed.
No, I'll keep it short. I promise. So we have been discussing the issue of diversity regarding domestic courts, though the issue of international judges has already been introduced. And now we move to the international sphere. And actually, I'm going to focus on the European Convention on the European Court of Human Rights and the Court of Justice of the European Union, which is more of a supranational court rather than an international one. And I'm afraid that probably I didn't send my title because, as I have seen, it was very broad in the program. So I apologize. I must forgot to have sent it before. So anyway. What I want to do here is to first analyze the reasons for diversity in the composition of international courts generally, and then to ask about specific sources of diversity at the international level, mainly geographical diversity, diversity on the basis of legal traditions, and gender, and see what are the reasons for each sort of diversity, and analyze the mechanisms that have been implemented in those 2 courts in order to advance that source of diversity. And actually, my goal is to, in a sense, be able to assess and critically analyze the claims of diversity and the specific mechanisms that have been implemented. And I must say that this is actually part of a broader project on judicial independence of international courts, and this is a new project that I am developing, so it is really a work in progress, and all comments, criticisms will be genuinely welcome. So first, regarding the main reasons for diversity, well, I I thought about giving you just this picture to cheer you up, given the time, which kind of reflects the reasons for diversity, probably. So what would be the reasons for diversity? Mainly, I'm going to be talking about these 5 categories. We've been discussing about that this morning, and probably there are other ways to present those. But basically, the way I see it is first a reason based on representativeness or representation. Obviously, adjudication is not regarded anymore as a simply syllogistic activity. There is room for interpretation. International courts engage in lawmaking. So to the extent that courts are conceived as political institutions, the argument would go about incorporating a notion of representation regarding the composition of those courts as a democratic value, to the extent that these courts engage also in lawmaking. On the other hand, though, this notion of representation might be in contrast with the requirement of judicial independence if representation is understood as representation of interests. So I'm very skeptical, actually, about using the notion of representation in order to justify normatively diversity in courts, if, as I said, it is understood as representation of interests of different groups. Representation might be understood differently. Actually, for instance, Matthias Kuhn distinguishes 4 forms of representativeness, talking about composition of courts. First, volitional, that would refer to the electoral link between judges and the people. Identitarian, about various groups defined in terms of race, ethnicity, gender, religion, nationality represented on the court. Argumentative, which would be actually about methodology, style, and structure of judicial opinions. And vicarious representation, which would be mainly about constitutional embeddedness of judicial institutions in the political system. And actually,
can you repeat the last one? I didn't hear.
The vicarious.
Vicarious?
Yeah, okay. And that's basically about the interaction between courts and other political institutions. And actually, he focuses on the third and the fourth, which are not so much about the composition of the courts, but mainly about judicial reasoning and the interaction of courts with other political institutions. So it's not so much, I mean, doesn't say so much about the composition of courts from the perspective of representation. So as I said, for me, representation probably wouldn't be the best way to go in understanding why courts should be diverse. So the second reason refers to symbolic elements, and we have been discussing about that. Diversity, in a way, furthers public confidence. It contributes to building a notion of fairness, inclusiveness. So there are elements that have to do with the symbolic presence of several groups of society in those international courts also. And I think that symbolic element, when I discuss later on the Court of Justice of the Union and the European Court of Human Rights, is very much present. Then the third reason for diversity would have to do with epistemical, it would be an epistemical reason regarding how the diverse viewpoints, experiences of judges might help to advance better reasoned outcomes. Actually, this was the argument of Laura, in a sense, right? Like how diversity in that sense of life experiences, viewpoints, contributes to the quality of decision-making and outcomes. The fourth reason for diversity in courts would have to do with equal access. So the lack of diversity might be understood in terms of procedures for selection and appointment of judges that contribute to disadvantage certain groups in society. Right? The idea is that even though those procedures, obviously, on its face are not discriminatory, the way they operate in practice have the effect of disadvantaging certain groups. And this is very clear at the international level, as we will see when I discuss the issue of gender. And finally, I would also like to present the issue of diversity in relationship with neutrality, in the sense that it is a question whether diversity is in tension or not with judicial independence more broadly. So let me just here refer to several notions that are very much interconnected: judicial independence, impartiality, neutrality. So very briefly, we can understand judicial independence as requiring that judges are not influenced or pressured by external actors. That would be like a very basic approach. Impartiality would be more about the lack of interests, of specific interests regarding the parties of the case or the object of the case. And then neutrality could be referred to the absence of bias, right? So even if there are no pressures from external actors, even if the judges do not have a specific interest in the case, they might be influenced by their own backgrounds, worldviews, experiences, and so on. So if that bias always exists, the idea is how to react to that. And here, for me, it's very powerful, the critique that Iris Young developed regarding the principle of impartiality. She talks about impartiality quite broadly, saying that, well, impartiality is at the end a fiction, right? It's impossible to think that somebody can be completely, have a view that is completely impersonal, dispassionate, completely separated from any particular context and commitments. So from the perspective of that critique, one way to go would be, well, to keep insisting on the need for judges to leave aside their experiences, their own views, and so on. But that might actually reinforce, as she also claims, right, the opinions of, or the approaches of the majority, right? Like to keep sustaining that ideal of impartiality masks, she says, the ways in which the particular perspective of dominant groups claim universality. So from that understanding, then, I think that neutrality is not so much about the absence of bias, but about the diversity of viewpoints and about the contrast of viewpoints of the different judges in the court through discussion, right? Through communication and dialogue. And it's from that perspective, I think, that we can conclude here that diversity might actually help to advance neutrality instead of seeing the existence of bias as something that undermines neutrality. This is also linked to what Laura was arguing before, right? How the contrast of different experiences and viewpoints might help to challenge the existing biases. So from that perspective then, and having in mind those 5 reasons that might justify diversity, I would like then to analyze the 3 sources that I referred before that have been relevant for international courts. And those are geographical diversity, legal traditions, and gender. First, regarding geographical diversity, actually that at the international level almost goes undisputed, right? That international courts should be diverse in terms of their composition on the basis of the geographical origin of the judges. But here the question is to understand why that is important, and I don't think it's so much about a notion of representativeness. Again, that might be problematic from the perspective of independence if we understand judges as representatives of the states they come from. And I don't think either it's a reason of an epistemic reason, unless we link that to the legal traditions from which they come. So it's basically a symbolic reason, I would say. Of course, we can imagine that human rights court, or if the European Court of Human Rights was only composed of judges coming from Western Europe, that would be problematic not only symbolically, but also from the perspective of neutrality and avoiding the dominance of some over the others. Right, so I think it's the symbolic reason linked to the neutrality element what would justify this geographical diversity. And there is an element also related to equal access here in terms of the equal sovereignty of the states, to the extent, and I will refer to that these courts that I'm analyzing have one judge per member state. So regarding the legal traditions, I would say there that the main element that justifies diversity in the composition of courts from the perspective of the legal traditions would be the epistemical reason, right? That to some extent here judges will participate in the decision-making process from the perspective of their diverse legal traditions, and that's important for the final outcome, so that can be a better reason if all those perspectives are brought to bear in the process of decision-making. And there are several actually studies about how that plays out, for instance, in the European Court of Human Rights. So taking into account those two elements, geographical diversity and diversity of legal traditions, let's then examine this rule, let's say, that is implemented in both courts, right? The fact that there is one judge per member state. Obviously, in other international courts in which there are less judges than member states, diversity for geographical and legal tradition, on the basis of geography and legal traditions, becomes a much trickier issue. But regarding the European courts, that diversity is somewhat secured on the basis of this correspondence of one member state or one judge per member state. But I want to problematize a bit this rule. Actually, there was, in the 90s, a discussion about reducing the number of judges of the Court of Justice of the European Union. And it's interesting to see how the court itself issued a report in 1995 analyzing the advantages and disadvantages of reducing the number of judges. And among the advantages, it was said that, well, as the EU was progressively enlarging, there could be a problem to the extent that then the plenary sessions would be converted into a kind of deliberative assembly, and that as a consequence of that, probably a bigger role would be for the chambers, and that posed problems for the coherence of the case law. So those would be arguments to reduce the number of judges. On the other hand, it was said it is good that there is one judge per member state, because then all legal systems, concepts are taken into account, and that furthers actually the legitimacy of the court and the acceptance of its decisions. Well, what happened nowadays is actually that, well, the full court meets very rarely. decisions are taken mainly in chambers or 3 or 5 judges, or, well, by the Grand Chamber, in which there are 15 judges. So if the reason for the correspondence of 1 judge per member state is the epistemical reason, right, that all legal systems are going to be taken into account, that's not the reality anymore, right? So if that's the reason, it doesn't justify the rule of 1 judge per member state. Actually, what we find behind that rule is more of the symbolic reason, and also the equal sovereignty, right? Equal access in terms of equal sovereignty. And a recent discussion about the General Court confirms that, right? There was for like a long time a discussion about about increasing the number of judges for the General Court, giving all the workload that court is facing. And there was a kind of plan to increase the number of judges of the General Court by 12, and also increase the number of legal assistants. But finally, and this was an agreement that took place last month, the decision has been to double the number of judges in the General Court, because the states couldn't agree about which state would get a 2nd judge. So at the end, that shows that what is behind this rule, it's just the idea of equal sovereignty, not so much the epistemical reason of having consideration of all the legal systems. Actually, that's probably much better served through other means, such as, for instance, the service of research and documentation that the court has with lawyers from all member states. They develop comparative law studies and so on. The situation of the European Court of Human Rights is a bit different, because giving up the rule of 1 judge per member state would mean that the national judge doesn't participate anymore in all cases about that state. And again, here, usually, the argument to justify the presence of the national judge is also that the legal system, the context, will be taken into account in a more profound way, since that judge might have a better knowledge of the legal system. At the same time, the presence of the national judge has been contested from the perspective of judicial independence. And here it would be interesting to have more empirical work to see what's actually the role of the national judge in cases against the respective state. And the work of Eric Beaton is very interesting here. He has analyzed the dissenting opinions, and actually he argues that there is no much evidence about the geographical origin or the legal system having an impact on the outcome. He says that there is some evidences of career and security after leaving the court that might have an impact on how judges decide. And actually, his argument is that mainly what makes a difference is their tendency to defer or not to the state of nationality. And what he found is that judges from former Soviet countries tend to be less deferent, actually, to their states. So, in a way, with the issue, I mean, what impact actually has the legal system, the legal system, or the presence of the national judge in the outcome of the decision is something that probably needs more empirical research. Actually, there is another study by Nina Luisa Arnold, who performed interviews with several judges at the European Court of Human Rights, and she concludes that, according to the views of those judges, that the geographical or legal background is the element that has the least impact on the decision. So that that might be, I don't know, surprising, maybe. In any event, the issue then here is that, again, I think that if the reason for the rule of one judge per member state is to have the legal system or to be able to have a better knowledge of the legal system, that's probably not, I mean, there would be other mechanisms to achieve that, such as through the law clerks, and not so much about having one judge per each member state. And what happens in practice nowadays is that the law clerk from the state that has been sued before the court is actually of the nationality of that state, right? The one that helps the reporting judge to draft the decision. Well, enough about the geographical origin or the legal system. I would just like to address the issue of gender very, very briefly, because many things have already been said this morning. And again, we could examine from the perspective of the 5 reasons I mentioned before, the issue of gender diversity on the basis of gender. And first, from the perspective of representativeness, I think that it's risky to justify gender diversity on the basis of representation for some of the reasons that were said before. For instance, that women judges do not necessarily advance or are not necessarily the ones who should advance a female agenda at the court, right? I mean, they are not supposed to represent interests as judges. And I find that the notion of representation at that level problematic from the perspective of judicial independence. There are for sure reasons that have to do with the creation or the advancement of a perception of inclusiveness, of fairness, of impartiality by having women judges at the court. Regarding the epistemical reasons, there is a lot to say there. For feminists, obviously, having women at the court is not just about that, but about having an impact on how the law is interpreted and applied. But again, here the empirical research is scarce in order to say, well, to what extent the presence of women has that impact. There are some studies in the US that are interesting to that extent from the 80s and the 90s, showing how when courts were mainly dominated by male judges, that there was a bias in cases regarding gender violence, for instance, or the racial issues, for sure, also. So, from the epistemical perspective, I would say that there are risks about, as we were discussing before, essentializing difference. There is no unique female perspective, and although we might have or we might defend that women will add a specific, I mean, not a single perspective, but something different on the basis of their own experiences and as a woman in society. Regarding the equality argument for diversity, I think that that's probably very strong here. And Susan Keeney, for instance, says that we should change the way we approach the issue, and instead of asking why women should be in the judiciary, the question should be why women are not, or why women are excluded, in a sense. And there I think there is a story of structural inequality that shows that even though the procedures for selection, I mean, obviously, on their face do not include any element to that in that regard, the way they work in practice have the consequence as on the basis of stereotypes, prejudices, etc., that exist in society to disadvantage women. And here, usually, the argument to oppose quotas or having gender into account have to do with merit. But for me, here, the argument of merit when applied to international courts is quite hypocritical in the sense that, well, the processes are not meritocratic, and that when many times it's just a phone call, the way in which judges are selected as candidates for these courts. This has improved over time, actually, but still, I think that it would be justified to incorporate the element of gender in one way or another, and I will talk about that in a moment, as the European Court of Human Rights, the European Court of Human Rights has done. And finally, regarding the neutrality element, I think that here that would also apply, right? That having a court dominated by male judges creates this sense of a bias that should be, I think, counteracted by the presence of women. So very briefly, because I guess there is no that much time left.
2 more minutes.
Okay. So very briefly, regarding European courts specifically, in the European Court of Human Rights, women amount to 30%, but that has increased over time. And actually, the Parliamentary Assembly here issued a resolution, as you probably know already, in 2004, stating that the Parliamentary Assembly would not consider those lists that did not include one candidate of each sex. In 2005, that resolution was amended in order to allow for all female lists, right? That the 3 candidates could be all female, not all male, because actually that was the purpose, right? To increase the number of women. So it was said, well, all female lists are going to be admitted. But then the problem from the perspective of gender balance, in a sense, is, I think, the opinion, the advisory opinion issued by the Strasbourg court regarding an all-male list submitted by Malta. The government argued that, well, that there were no female that had enough qualifications to be candidates for the European Court of Human Rights, and that nowhere in the convention it was said that that was a requirement. Here, the European Court of Human Rights actually decided that all male lists could not be automatically rejected, and that not allowing any exceptions was incompatible with the convention. So the resolution that had been passed before was amended in order to incorporate the clause that you can see in the screen now, that the Assembly could consider single-sex lists of candidates of the sex that is overrepresented in the court in exceptional circumstances where a contracting party has taken all the necessary and appropriate steps to ensure that the list contains a candidate of the unrepresented sex, but has not been able to find a candidate of that sex who satisfies the requirements of the convention. So on the basis of that, later on, all male lists have been submitted to the Parliamentary Assembly. And the case of Belgium was very much contested. The government argued that among the candidates that were interviewed, there was only one woman, and although she had the competences to be appointed, the male candidates had more qualifications. And the list went through. For me, that's problematic because actually it's not in compliance with that, since according to the resolution, only all male lists will be considered if there has not been, if the state has not been able to find a candidate of the sex who satisfies the requirements. And the Belgian government acknowledged that the candidate, the female candidate, had the competences It's just that the argument was that she was not as qualified as the male candidates. So, in a sense, first, I think that that's quite unfortunate. I mean, to admit that a state cannot, find a female that is qualified to perform the task of a judge of the European Court of Human Rights. But having that resolution as it is right now, at least it should be applied properly. So that for the European Court of Human Rights. Regarding the Court of Justice of the European Union, the situation is even worse, right? There is a percentage of 17 women at the court, at the Court of Justice, 17%, and actually I have here the figures. These are 5 women out of 28 as judges, and 2 women out of 9 as advocate general. The issue of gender has come out at some point in the European Parliament. Actually, the European Parliament has been claiming for more participation in the process of appointing judges to the Court of Justice, although right now it doesn't have a role. And if we take gender balance seriously, I think that a lot more could be done at the Court of Justice. It's true that since the member states propose just one candidate, right, to the council, it's more difficult to implement a sort of a quota as it has been implemented for the European Court of Human Rights, but still that more could be done. So finally, the idea would be for the future that this picture doesn't look too similar to the previous one that we saw in the presentation. So thank you so much, and now, I will be happy to.
Thank you. I'm sure there will be. Anybody wants to start? Yes, Marco.
Thank you, Aida. It was a great presentation, and I would say also very persuasive. When you were presenting, I was thinking that in the European Union, there is another institution which is supposed or expected to be independent and which has more or less the same problem, same representation for each member state, which is the Commission. Mm-hmm. And the members of the Commission are expected to be independent, not to accept instructions from private parties, from national governments, but this is the official language. If you do some empirical research, you notice that the role is much more nuanced. Commissioners have a gateway function. They are, of course, independent. They are expected to be independent, but at the same time, they have a role to represent in the Committee of Commissioners the views of the governments involved, or the sensibilities of national politics, let's say, and to, for instance, represent what could be the impact of a certain decision in a certain member state. And this is more or less accepted as a function, as a matter of fact, not as law. Which, again, echoes what you were saying about the Court of Justice. Is there an expectation, are those judges, one judge for each member state, expected just to be a symbol, or do they perform some representation function within the ECJ? And you're probably right in saying that we don't find a lot of representation for the reasons you mentioned, that the Court of Justice increasingly decides with chambers of 3, 5, 15 judges, so there's no possibility in each case for a national judge to represent the claims emerging from a national legal system in litigation. But my question here is the following. Would it be desirable, for instance, to have, at least in salient cases, the member of the Court of Justice of the legal system involved to be present in the chamber or discussing the case, exactly to perform that gateway function, to represent not much the interest of the government at stake, but the legal culture involved in the case. I'm, of course, referring to the debate on constitutional identity. For those who are not experts in European Union law, there is an expectation that in deciding cases, the Court of Justice takes into account the constitutional...
If I may, it is an obligation.
Yeah.
Okay. The European Union shall respect.
Shall respect, okay. You're right, Roberto. So, is this desirable? I don't have strong views on this. I'm just asking a genuine question. Would be expected for instance, if a case arises from, let's say, Germany, and there is a discussion on, let's say, whether the OMT is legal or not, would it be desirable to have in the chamber discussing the case the German judge there exactly to perform this gateway function to represent the national legal culture at stake? Of course, in that case, it has been quite strongly represented with a preliminary reference.
More questions? Yes, Matthias?
Thank you very much.
Oh, I'm sorry. Yeah, okay. You can write after. I had forgotten.
Thank you. The role of the national judge in the international court, specifically, of course, here I'm talking about the Strasbourg court. In a way, it's still the role of the ad hoc judge we have at the International Court of Justice. You know, this where a country which is having a case before the court and having no judge on the bench has a right to appoint a judge in order to be better represented in a way. And here I think the judge, the national judge, has a double function. On the one hand, he or she shall make an input into the interpretation of the international legal order from the viewpoint of the given state or the given legal culture. And on the other hand, he or she is the expert of the law which is under review. And here, this is of a specific importance with respect to the European Court of Human Rights, and I already mentioned it before. Of course, English and French are the official languages. However, if a person from Georgia or a person from Estonia is handing in a claim or complaint, very often it's not written in English at the beginning or in French, and so it has to be checked. The first thing, and then has to be translated. And then perhaps it's referred to a given provision of the civil code, but this provision can be understood only in the context of the civil code, so you have to know all the other cases. It's of course impossible to have the civil code of Georgia translated, of Estonia translated, so, and then the interpretation, the case law, etc. of the given state. And everybody is depending on the Georgian judge or the Estonian judge in this case. Therefore, it's even necessary to have them there on the one hand. And on the other hand, again, I repeat this question, isn't it a risk for the independence of all judges, that they are depending on one who knows the language? Thank you.
Thank you. John, Morrison, and Alexandra. Anybody else?
Thank you. I enjoyed your presentation. I particularly liked the way in which you went into some detail about the reasons for diversity. But may I say, I think you perhaps missed the most important, or certainly the most compelling reason for diversity. That's a very pragmatic one. I suppose any judiciary, you're seeking the best possible judiciary. So there's an argument, surely, an argument about missed talent. Unless you believe that legal ability, people skills, other transferable skills, the potential to be a judge is distributed unequally so that it tends to be men who for some reason have all those skills, unless you're actually looking for a diverse judiciary, you're not finding the place where those skills will reside. In other words, those sorts of skills are most likely to be distributed more or less evenly across men and women, across different racial groups and so forth. Now, surely that seems to me to be the raison d'etre, the whole idea behind getting a best possible judiciary, the whole rationale for diversity. It's also, may I say, the most compelling one, because it's one which you can use as an unanswerable argument to those who might say, well, things are okay the way they are?
Alexandra?
Thank you. Yes, I found the paper really interesting. You dealt with ethnicity and you dealt with gender, but of course when it comes to the European Court of Human Rights, there's another elephant in the room, and this is religion. And the European Court of Human Rights has been heavily criticized for its judgments in matters of freedom of religion and in manifestations of religion in public spaces. So, religious clothing, but also crosses in...
symbols.
Yes, symbols, thank you. So, religious symbols, thank you. But also with the parties, the political parties. So, generally, kind of manifestation of broader issues of freedom of religion. And one would think that, for example, Muslims now in Europe must be, more than... I don't know the exact numbers, definitely more than 5%. Would they go even more than 10%? I can't tell you, but they're a substantial minority. And they're not represented because, of course, the tap on the shoulder, about who's going, and the nod about who's going to become the national judge comes from among the dominant, the elite of the state, and the elite of the state is the majority. And so I was wondering whether you're going to deal with that as well, and whether you have any ideas. And no, I'm not advocating that there should be a quota for a Muslim judge, but I was wondering whether you're going to reflect on this as well. Thank you.
Gracie?
Thank you. I apologize because I don't know if my question may make sense, but I was wondering if what is the role of the function of the Court of Justice? I'm thinking about the preliminary ruling. So the Court of Justice is not taking the final decision in these cases, but is just interpreting or the validity of interpreting EU law. So I'm thinking about, for example, the Chen case, and I was wondering if diversity becomes more complex when you think about preliminary ruling, or just the preliminary ruling has a diluate in some way this problem of diversity for the Court of Justice. This is linked to another thought I have. Is the judges of the Court of Justice representing national diversities in the court, or they are promoting their own vision of diversity? So they are as a group of judges another factor of diversity. They are not reflecting the legal traditions from which they came from, but the EU identity in a way. I'm again thinking about cases involving Zambrano, for example, or especially these cases where there is this problem with purely internal situations. So where you really see that this detachment from somehow national judges or courts.
I have, okay, yes? Yes?
I was just asking a very brief question on the merit of international judges, because we have spent a lot of time this morning talking on merit-based appointments, and my question would be whether there is something like this Article 255 panel also in other jurisdictions at international level, if you are aware of this.
Now, I have a few remarks. Now, first of all, I heard a couple of times yesterday and today an association between gender balance in courts and feminism. Now, I don't think this is a feminist issue. I think this is an issue for citizens at large. It may be that some groups are pushing forward, but as scholars, I don't think that we should take the attitude of feminism, but the attitude of what is the interest of the community at large. Secondly, and this is a question, of course there are many differences between the European Court of Human Rights and the European Court of Justice. I wonder if some of such differences may be related to the very purpose of the European Union, which is integration, whereas integration is not the purpose of the European Convention of Human Rights. For instance, the fact that there is no requirement of a presence of the judge elected for that particular state, as we have within the European Convention. One of the reasons might be precisely that in one case the purpose is to integrate legal systems, and in the other it is not. I think also that some differences might also serve in order to better understand the rationale of each system. For instance, in the European Court of Justice, not only there are no concurring and dissenting opinions, but there is a commitment, if not an oath, of the members that they must take when they are appointed, that nothing will be made public, nothing of the decision-making process will be revealed to the outside world, which means that there is, I would say, an obsessive emphasis on secrecy and lack of transparency. And I hate to say that, but I wonder if this has anything to do with the fact that the members of the European Court of Justice may have a new term, whereas members of the European Court of Human Rights cannot have a new term. So, complete secrecy on the one hand, renewable term, secrecy, and one fixed term. So I think that this difference may suggest some explanations. Coming a little bit to the ground that has been dealt with by Marco, and asking Fred perhaps to help me. I remember, not that I was there, but I read it about some 30 years ago, that after a very controversial case in the US, perhaps Baker versus Carr, 1958, which really was intrusive within the sovereignty of states because it had to do with electoral constituencies. Somebody has suggested a modification of the federal constitution to the extent of establishing a superior court of the United States composed by the Chief Justice of the Supreme Court of each member state. Do you know anything about it? Because I read it, and I find it fascinating because it shows, I would say, the rationale of a sort of, let's say, coordinated higher court, or a higher court which is really having some function of integration. So, for instance, in the issue which has been raised by Marco, deciding whether provisions of the European Union do violate or do not violate the constitutional identity of member states, it might be suggestible that one should have a court which is composed by presidents of national constitutional courts, because they would really solve the issue rather than letting it to the Court of the European Union. Of course, it is provocative, but Okay, well, I didn't know that. So somebody read Baker versus Carr and the reactions to Baker versus Carr. The point is that we really have, I would say, to enter the rationale of these courts, of both the European Court and the Court of Justice. And I would say they are quite different from the International Court of Justice or any other institutions that might be comparable.
Okay, great. Thank you.
Okay, you have 5 minutes.
Perfect. Let's see what I can do with 5 minutes. Anyway, regarding the Court of Justice, since, well, there were like several points about the Court of Justice of the Union, And there, I think that in practice, actually, although there is this rule of one judge per member state, the member states have given up having the national judge present in the case that is discussed when that state is sued or when there is a preliminary reference from that state. So that's why I think that the argument to sustain that rule cannot be that the judge will provide for that expertise or knowledge more profound about the legal system of that state. So you're telling me whether it would be good to incorporate then the judge for that same reason, and I don't think so, actually. I mean, I think that there are other ways we can think of in order to provide the court with that information, in a sense, that has to do with, as I said before, the service of research and documentation that the court has with lawyers from all member states. To some extent, the use of the law clerks that might be helpful there too. And actually, in preliminary reference procedures, you have the national judge telling the Court of Justice of the Union about the law of that member state. And the preliminary reference can actually be used in a robust way to provide that information to the Court of Justice. And actually, even the state governments the state government can participate and also provide more information to the court. So I wouldn't say that would be a reason then to incorporate also the national judge there. And that actually, I can link that with the point that Matthias made also regarding the value of having the national judge in the European Court of Human Rights. And I can see that for sure. But for instance, the Inter-American Court of Human Rights, since there are only 7 judges for all, so they don't have, I mean, there is no possibility then to have the national judge for each member state. Well, yeah, I mean, yeah, the language issue makes a difference there. But then is where also the role of the law clerk comes in. Since in practice, the national law clerk actually is the one drafting the decision. So if the issue is mainly about language and learning about that legal system from within, I don't think it's necessarily the judge the one who has to provide for that there are other means. No, but that's the thing. No, I mean, I perfectly see the argument, but that's the thing. There are human rights courts. It's true that you're telling me, well, but the language there is a difference in the Inter-American Court.
Jamaica is English-speaking, isn't it?
Yeah.
Yeah.
Yeah, of course, yeah.
Yeah. So, but actually, for me, that's a balance with the issue of judicial independence. And I think that that from that perspective, the presence of the national judge is problematic, both for how faithful the judge might be or not to that the government that appointed him or her, but also from the perspective of the judge himself or herself, right? That might be that having to decide of cases that relate to the member state. I mean, that might pose problems from the perspective of that same judge. And actually, talking to judges of the Court of Justice of the Union, they were telling me that the fact that there are no dissenting opinions for the Court of Justice is a way to protect their independence, even though actually the national judge does not participate necessarily in cases before the Court of Justice of the Union, whereas when we go to the European Court of Human Rights, the national judge will always be there with the possibility to make a dissenting opinion or not, and that might be, that might be something that might undermine at least the perception of judicial independence regarding the broader public. So, I mean, I for sure see the benefits of having the national judge in there, but I'm not so sure whether that's a winning argument in order to keep the rule of one judge per member state, and that there may be other ways to, I don't know, to confront the problem that you were referring to. Regarding, John, you were telling me that, well, maybe a reason for diversity is merit, as if the assessment of merit would, or just merit would necessarily bring diversity, right? But actually, I come to your presentation that how merit is framed and assessed might reproduce some stereotypes, prejudices, and might actually work to disadvantage certain groups. So although the goal should be to have the best judges, the way in which the appointment process works might have the consequence of having a less diverse court, right? Since the way we define merit might actually undermine the possibilities of, for instance, women to get to the court in a way.
Well, I think in a sense I was trying to suggest.
Yeah.
In a sense, I was trying to suggest that it's further evidence that we have misdefined merit.
Mm-hmm.
Because unless we think somehow or other, as I say, merit is uniquely belongs to men, which is a tempting idea, but I don't think I can get away with that. Mm-hmm. We have to say it's distributed equally. Mm-hmm. And if we're not getting equal numbers of men and women on the bench, we've got it wrong somehow. So it was a simple, it was a simple point.
Right,
that's a
right.
good sense.
Yeah. No, that's for sure. Yeah, that's. But that's why I think it's this clause that has been introduced in the resolution about the possibility of having all male judges or all male candidates when it has not been possible to find a female candidate that is sufficiently qualified is nonsense, right? I mean, it's hardly conceivable that it's not possible to find a woman that is qualified enough to fulfill that position. But that is something that the court has endorsed. Actually, the resolution was amended as a consequence of the advisory opinion by the court. Regarding the issue of religion, that's something I actually need to think about, because it's true that I focused on gender since the discussion has been mainly about that. But obviously there are criticisms directed to the outcomes of the European Court of Human Rights from the perspective of religion bias, let's say, and how cases that have to do with, for instance, the crucifix here, the Italian case, or as opposed to cases that have to do with the burqa and so on, yeah. So for sure you can say that those cases might have been decided differently in terms of the religion that was involved and whether the presence of Muslim judges or whatever would make a difference there. But that's something that, I need to think over. I have a friend working on those issues, and she would say that probably the identitarian claims are not, that now groups are seeking for redress before courts, and probably courts are not the best place to...
I would say it would be very provocative to have a Muslim lady judge at the European Court of Human Rights. That would be the best answer.
But there is the United Nations has now UN bodies that are more diverse have now given opinions that go contrary to the judgments of the European Court of Human Rights and the emphasis of the European Court of Human Rights on secularism and this construction of neutrality, etc. So in this respect, you can make the argument that, when there is diversity, things are kind of different.
Then UN institutions are political and are not judicial.
Yes, absolutely.
So
that's why I said you could make the argument.
Okay.
Yeah, no, for sure that's an issue. And then regarding, well, the assessment of merit and how these advisory panels that have been introduced might help to advance decisions or appointments based on merit. For sure, I think that the 255 panel has had an important role to the extent that the appointment process is no longer exclusively in the hands of state governments, and it has had some bite already and has issued, I think, a total of 7 negative opinions. They are not that many, but still, and that the candidates had been withdrawn, and so that it's having some impact from that perspective. Actually, a similar panel was introduced for the European Court of Human Rights on the basis of a decision by the Committee of Ministers, actually inspired by the 255 panel. But there, the operation of this other panel, well, it has been more contested. It works a bit differently. That panel will issue also an opinion about the merits of the candidates, but this is before the Parliamentary Assembly intervenes. So it's more like an opinion directed to that specific government, to allow for the government to present another candidate before the interviews in the Committee for Election of Judges take place. Actually, this other panel, the one in the European Court of Human Rights, doesn't perform interviews. So it's a kind of a first assessment of the merits. But apparently there have been occasions, at least one that I know, in which the panel issued a negative opinion, and still the government kept the same candidates, and the list went through. Well, those were the candidates that later on were interviewed by the Parliamentary Assembly. So there is an issue regarding these panels about transparency, actually, and because all those opinions are not public, so probably they could have more of an impact if more transparency was introduced. Although this is a very contested issue, the one of transparency of the work of these advisory bodies. And finally, regarding your questions, Roberto, the question of gender, I mean, when I was analyzing the reasons for gender diversity, I referred to the issue of feminism, because sometimes, and from the more epistemical perspective, it is said that, and from the feminist perspective actually, that it's not just about having women in the judiciary, but having an impact on how law is interpreted, facts are approached, and so on. But at the same time, we were discussing this before, this argument has downsides about the risk of essentializing difference. It is not, we can say, the case that all women will have a unique perspective, and so on. So I think that the argument that has to do with exclusion in the process of appointment and selection probably is more powerful, I would say, in introducing mechanisms such as a sort of quota in the European Court of Human Rights. So the idea would be there, well, if women are equally qualified than men, how is it that usually we have gotten just male candidates? So let's introduce a requirement for having at least one female candidate. And I think that is, I mean, that mechanism is linked to the argument of exclusion, in a sense that that's what you were advancing, talking about this is an issue at the end of the society at large. And yeah, well, regarding the differences between one court and the other, for sure, when it comes to the fixed term of the European Court of Human Rights, the issue of judicial independence was very much present in that case, right? Of having a fixed term instead of instead of the possibility of renewing the judge. I think that actually judicial independence and the need to secure that was, and actually that's the explanation that the for that amendment, right, to secure judicial independence, and many have argued that also that should be something introduced for the European Court of Justice, right, like have longer terms and non-renewability, and well, let's see if that ever happens. And then you had a point of whether the difference about having the national judge or not had to do with the goal of integration itself. I need to think about that, but you could say that the European Court of Justice, to the extent that it is a supranational court and not so much an international one, that's why maybe the issue of the national judge is more diffused, right, in the sense that, as we just discussed before, the national judge is not necessarily present in the chamber that will decide. And actually, I think that that's coherent with a notion of a supranational court vis-a-vis an international one. But still, the rule of one judge per member state prevails, and we have seen that in I just mentioned, for the General Court, that there was no agreement about which member states would have the possibility to appoint a second judge. So finally, the decision has been to double the number of judges.
It's true also that we're in a stage in which everything is intergovernmental.
No, but that's, what I feel is that...
Two steps backward.
Right, yeah, that's what I feel with that discussion, that what shows that is that even though we are, that's a supranational court, the issue of intergovernmentalism is very much present. Yeah, and well, I think that's pretty much it. Thank you so much for all the...
Thank you very much.
All the, all the comments.
I hope this will be useful for the continuation of your project.
Sure, yeah.
So it's, okay, now I think that just to follow the program, I should say something in terms of concluding remarks. And I would really ask very much Jens to come here and sit at the table, or there perhaps, so that perhaps you may like to add something. I'll try to be really short. First of all, because it is very difficult to try to sum up what has been said, and secondly, because everybody is quite tired, and I am tired myself. But I did write down some notes before, between lunch and the first session today. So let me just start by saying that there are many ways through which you can approach scientifically the topic of the judiciary. I think that we have dealt with the topic of the judiciary in a rather original and innovative way, as we have dealt with the judiciary as it is affected by pluralism. And I think it is a non-common way of approaching the issue of the judiciary. Of course, this was not out of fantasy and imagination, but because we have been looking at historical phenomena that shows to what extent pluralisms do affect the organization and the function of the judiciary. In some cases, such historical phenomena are work in progress. In some other cases, the phenomenon is much more established historically. Certainly, the two main pillars of our object of analysis have been cultural pluralism and territorial pluralism. I would say that territorial pluralism is a well-established phenomenon when, in the way it affects the judiciary, whereas cultural pluralism perhaps is more innovative. Now, the fact that territorial pluralism is a well-established element of the organization and the functioning of the judiciary has been very well described in the paper on common law federal systems by Cheryl. And I would say that within the same line, but with a different approach, also the presentation of the Judiciary of the Russian Federation is in the same direction. More innovative features are those connected with cultural pluralisms. We have seen, thanks also to a presentation by Alexandra, the consequences of the UN Declaration, and we have seen that also in the presentation on Malaysia and Singapore. And I think Malaysia and Singapore were particularly interesting because they put together, at least when it comes to Malaysia, elements of territorial pluralism, and in both cases, Malaysia and Singapore also cultural pluralism, in particular religious pluralism. Now, all this put together has opened the way to diversity in the judiciary, which has been dealt with yesterday in a number of papers and today. Now, diversity in the judiciary may be connected with conflict, as in the case of Northern Ireland and in the case of Bosnia-Herzegovina and other cases. But diversity, both with regard to gender and other minorities, has been also very well illustrated with regard to England and Wales, to Australia, to South Africa, in the presentations by Debbie Mortimer and Laura Healy. Let me add that diversity in the judiciary, at least as far as I'm concerned, has been described in a rather innovative way by Fred Eman, in particular as a social opportunity, as one more choice of social emancipation of members of marginalized groups, and this has proved to be quite important also in other environments than the United States. But still, papers have also highlighted to what extent diversity is one more source of confidence, one more source of legitimacy, in particular in fragmented societies, and we know that all societies in which we live are fragmented and tend to be even more fragmented and divided. Now, of course, it is important to underline, from what I understand and from what I think, that diversity as a source of confidence and legitimacy is to be regarded perhaps as one of the elements of fairness and impartiality. Perhaps it is a way for strengthening fairness and impartiality, or otherwise it must be seen alongside with fairness and impartiality. Of course, not with regard to the outcome, or at least not necessarily with regard to the outcome only, but rather to the fairness of the judicial process as a whole as it affects the outcome. So I would like to not to put into direct connection diversity and the judicial decisions, but diversity, the judicial process, and the final decision. The same approach, I would say, applies to what has been said about foreign and international judges as stakeholders of the, let's say, benefits that the judicial function is expected to produce within a given system. And one might say that there is a new component of fairness and impartiality when it comes to foreign and international judges, although it will be difficult to reduce the plurality of experiences to one pattern only. So diversity in the judiciary is diversity within the judiciary. And mind you, I think from what we heard today and yesterday with regard to Australia, with regard to New Zealand, diversity within the judiciary is an alternative to separated judiciaries. Now this might be, the goal of having separated judiciaries might be more appropriate when it comes to a set of issues with indigenous peoples, although, in other words, it is likely to be appropriate to allow indigenous peoples in the exercise of their own autonomy to decide a set of cases which I would have difficulty at the moment to define, perhaps when there is no further interest at stake which is to be regarded as worthy of consideration. In other words, in a number of cases in which indigenous populations do not interact with the rest of the population. Of course, this is also very delicate because in many cases, land ownership is a reason for interaction and, for instance, in terms of obstacles to some development plans. There is an interesting number of decisions by the Inter-American Court on Human Rights, for instance, transforming the violation to the right to property into an obligation to be consulted, to put conditions, and in case consultation has not been properly prior, the Inter-American Court of Human Rights went as far as forcing the government, the authorities, to publicly excuse themselves for having neglected to take into consideration the view of the indigenous populations. So I would say, looking at some countries where the indigenous populations are a reality, you may have some conclusions that are not, or some solutions which are not necessarily the same that you have for society at large when you don't have a physical separation of the population as such. At the same time, we shouldn't forget that also in Europe, and certainly in civil jurisdictions in Latin America, the issue of cultural defense, in particular in criminal matters, has been raised and is being raised quite often. So that is another indication of interaction between indigenous populations and the rest of citizens, which in a way introduces elements of diversity within the judiciary. What I think is extremely interesting is to examine the sources of diversity, the legal sources through which diversity penetrates the judiciary. In some cases, you have practice or practices. Now, for instance, there is an experience in Italy which concerns pro-system and anti-system parties. For many years, the 5 constitutional courts that were elected by Parliament, by both chambers of Parliament, with qualified majorities, were selected with, were indicated only by the political parties that had voted in favor of the Republican Constitution. Those parties that had not voted in favor of the Constitution were kept out. The idea being not that they did not deserve to participate to the composition of the court, but they did not express the sensitivities that were necessary in order to fully understand and implement the Republican and democratic Constitution. So that was only a practice. It never went beyond a practice. In particular, if you're interested, out of the 5, 2 candidates were suggested by the Christian Democrats, one by the Communist Party as the largest party in the opposition, one by the Socialist Party, and one every 9 years by one of the 3 major partners of the coalition. So everybody was pleased, even though in a longer period of time. So anyway, in some cases you have practices, and also the practice, which is mainly political, according to what Fred told us, of having sort of reserved chairs in the Supreme Court of the United States. But then in some other cases we have legislation. That's the case of Belgium. That's the case of Switzerland. I'm sorry we didn't speak enough of Switzerland today. In some other cases you have conventional criteria, as in some Latin American countries, where you have agreements which lead to accepting different candidates. In some cases, we have constitutional law, as in the case of South Africa and Macedonia, of course, what I insist on calling Macedonia. So we have a plurality of sources precisely because we have a plurality of situations and a plurality of solutions. And from this point of view, once again, let me say how much I appreciate the idea of engineering that John introduced. I think this is really part of engineering which applies to the whole of constitution making. So this, I would say, one specialized area of constitution making, or, if you like, of making use of other sources of law that introduce diversity within the judiciary. Precisely because it is, I would say, an art of engineering, I insist very much on trying to avoid, as far as I'm concerned, the very word representation. Because representation, at least in this context, is a hybrid, and it does raise more confusion than clarity. And that's why I insist on reflection, or as I did in a writing of mine, the judge-member state connection. I would just try to avoid the notion of reflection. Also because in many cases, and this has been so lucidly told us by Debbie Mortimer, what really matters, or what may be even a substitute, is the awareness of diversity. And of course, that is very subjective. I wouldn't take it as a sort of standard to be generalized, but still it is particularly important. And it is awareness of pluriculturalism, multiculturalism, interlegality, legal pluralism. We have mentioned all these different approaches and theories of law. So the plurality of solutions, the engineering, very much have to do with improving the quality of justice, as Laura Healy told us. And this is, I would say, a very promising, but also very challenging perspective. Diversity as instrumental to the quality of justice. I like to think of diversities as instrumental to the quality of justice in terms of favoring the awareness of human dignity within the judiciary, in the exercise of the judicial function. And as far as I'm concerned, whether it is pluriculturalism or multiculturalism, whether it is interlegality or legal pluralism, I think that all of them converge in supporting this value, the value of human dignity, of quality of justice, and eventually equality. And it is from the point of view of equality that I would like, again, to point out how you can look at things in a different way. For instance, we all know and have celebrated in different stages of life the well-known expression of a colorblind constitution. Now, a colorblind constitution is very important, but where I am a member of a minority, I would prefer to have a color-conscious constitution. Now, of course, both statements, I would say, are correct. It depends on the situation in which you are and in which you want the system to operate. So finally, I would say that the issue of diversity of the judiciary is another way for examining what constitutional law is and possibly improving constitutional law in order to make it an instrument of protection of human dignity, equality, and quality of justice. So these are a few words that I think may somehow wrap up all the richness, great richness of what has been said today in these 2 days. And I'm personally grateful for you, not only, let's say, on behalf of the research project, but personally also because I have to say that I enjoyed every minute of our seminar. So, Jens, anything that you would like to add?
I'm tempted not to, but it's, I really try to make it very, very, very short, because I was really struck by the quotation you have put on your final slides, which was by Young, Justice and the Politics of Difference, about the ideal of impartiality. And this, I think, very much fits to what you just said and adds the power dimension, which was implicit in what you were saying, but I think makes it very implicit. The ideal of impartiality serves ideological functions. It masks the ways in which the particular perspectives of dominant groups claim universality and helps justify hierarchical decision-making structures. I think this is a very nice also summary of many of the debates we had, and we can, of course, now turn this around into positive, and this fits of what you were saying with diversity. And here I already come to the end of what I wanted to say. I think this is actually very much linked to the final aim also of our research project in looking for a kind of sustainable pluralism and sustainable ways of pluralism, and probably having a different understanding of impartiality as what is expressed by this quotation, opening up even on the price of giving away some power, is probably a kind of maturity indicator for pluralist democratic societies.
Very good. Of course, we also thank very much the staff who is present today, and who is not present at the moment, but please let George and the rest know how much we appreciate. We also appreciated the catering very much. I keep listening how well organized it was, although it was very, very simple, very essential, and so it was really very enjoyable. Then we should perhaps close the internet connection and talk about dinner.
Good idea.
In a more confidential way.